Destiny Graves. This is the city of Detroit, Mr. Berry versus Destiny Graves, case number SB 16, strike that, SB 1069059, counts 1 and counts 2, SB 172478881, SB 1724805, counts 1, 2, and 3, and SB 1724836. Appearance for the city, Mr. Berry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Graves.
Good morning, Your Honor. I am Destiny Raven Graves. That's capital D, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES. I am appearing specially and not generally. I am here in good faith and under the protest solely to address the matters raised in my plea abatement. I am not here to delay the process, but to ensure proper identification and lawful jurisdiction are established on the record before any further proceedings.
All right, good morning to you, ma'am. Today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or no?
I'm sorry, can you repeat that?
I said today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or not?
I actually am not open to proceeding until we establish jurisdiction over the living woman. That's me, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES.
Buckle up, guys. Today we're diving straight into the courtroom chaos. Judge Perkins is on the bench, and right off the bat, the tone is set for something wild. The host teases what's coming. A soft Karen, trying her luck with the sovereign citizen routine. It's that calm before the storm moment when you just know things are about to spiral into courtroom comedy gold. Let's get into it.
Jurisdiction has been established if you are Destiny Graves. If you're Destiny Graves, if that's your name, then unless you have some other view of the court rule and you cite a court rule, the court is going to feel the jurisdiction has been established.
I understand, Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity. I respectfully require the court to establish, for the record, how to obtain lawful personal jurisdiction over me, the living woman, separate from that entity.
Well, I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. I can either give you into the breakout room with the city with an attorney, and he can help you proceed, or you can proceed and speak to the city attorney yourself to see if you can work this matter out, or I can set a jury trial date and the matter will be resolved on the jury trial date. Which one would you like to do, ma'am?
Are you asking me if I would like to proceed for trial?
Yes.
I would respectfully, Your Honor, I would like to reserve all my rights under the UCC 1-308, and I object to these proceedings under protest and duress. My appearance is special and not general. I do not consent to the court assuming jurisdiction through presumption. If this court insists on moving forward without proving lawful authority over the living woman, I must note a violation of due process for the record.
Okay. So, I mean, if you can't give me an answer to my question, then I'm going to put you back in the waiting room until you can figure it out, and we'll move on to the next person.
What is your question, Your Honor?
I asked you, do you want to see if the attorney can get you an offer and speak with the attorney, or would you like to work out an offer with the city yourself to resolve the matter or would you like me to set a jury trial date? Those are your three options. You keep on saying that same stuff is not gonna change what your three options are, okay? So that's, I don't need to hear that same recitation of what you just mentioned a minute ago. Now, what do you wanna do?
So I'm sorry, respectfully, Your Honor, I do want to know, is this denying the abatement plea?
Say that again?
Is this denying my abatement plea?
I'm not getting into this, ma'am. I'm gonna pass the matter.
All right, guys, here's where the sparks start to fly. Destiny Graves steps up, spelling out her entire name like it's a legal code and proudly declaring she's appearing specially, not generally. The air shifts instantly. You can feel the judge's patience start to thin. It's a textbook sovereign citizen performance, complete with wordplay and self-proclaimed jurisdiction challenges. You just know this isn't going to end smoothly.
Mr. Atkins.
No, you're over there.
All right, this is cause number CR 22-368, State of Texas versus Seth Edward Atkins. All right, Mr. Atkins, the state has filed a motion to adjudicate your guilt and to revoke your community supervision. I want to take a moment and display on the screen their allegations before we have a conversation about whether or not you want to proceed and represent yourself. Okay, can you see that on your screen?
Yes, sir. Oh, okay. Can we go back up? Just fine.
Hey, I don't want you to say anything. I just want you to read.
Okay. Yes, sir. Yes, sir.
All right, so Mr. Atkins, I don't want you to say anything other than to answer my questions that are going to be limited to the discussion of whether or not you want to represent yourself. Now, that's been indicated to me by Ms. Tabraham in your own words without telling me anything about these allegations or your case, why it is that you want to represent yourself.
Don't really trust lawyers anymore, and I'm more than qualified to represent myself, like Mr. Martin. So if you want to give me a court-appointed attorney, then go ahead. Please, sir.
Do you want a court-appointed attorney?
I just want y'all's help to fix all this. But yes, I would.
Okay.
I would like a
Well,
court-appointed.
you told my coordinator there that you wanted to represent yourself, and you do have a constitutional right to represent yourself. However, as the judge, it's my job to ensure that you are adequately warned about the dangers of doing so. And so I wanted to give you an opportunity to tell me why you wanted to represent yourself. And obviously, that's the first thing that you've said to me is that you have a religious belief that that Christ said not to trust lawyers because they're bought and paid for. If you can't prove that to me, then we can go on and we can talk about your other points. We can talk about your education, we can talk about your legal training, talk about your familiarity with the rules of criminal procedure, we talk about the advantages, the disadvantages, we talk about your rights. We can have that discussion. I have no problem with it, but I want you to be heard first. And then it's going to be my opportunity to evaluate whether or not I think that it's appropriate for you to have a court-appointed attorney or rather to represent yourself. If you insist on representing yourself, then I will do my job and I will go through the threat of warnings and I'll weigh that. I'll make that decision. If you're telling me that you have a natural distrust of lawyers, okay, that's fine. But you understand, Mr. Atkins, though, that even if an attorney is appointed to you, you make the decisions on what you want to do, whether you want to play true to something, play not true to something. You and you alone get to make that decision. No attorney gets to substitute their decision for your decision. So you are in control. The attorney works for you and helps you to understand the law, helps you understand the weight of the evidence, it helps you understand how to make an informed decision based on the allegations against you. Now, we find that you're indigent and that you are eligible for court-appointed counsel. If you want court-appointed counsel, that attorney will be appointed to you, and then you can discuss the case with them. And then they come and obviously they make the arguments before the court, and they are your representative in court. And at this point, you have an opportunity to have one of two things. You can either negotiate some kind of agreement to resolve the accusations, or you can request to have a hearing in which the state of Texas through their prosecutors will be, they'll bear the burden of proving the truthfulness of the accusations beyond the preponderance of the evidence. It's a lower burden because it is a revocation and it's not a trial on beyond a reasonable doubt. And if they approve that, then you could be revoked and sentenced anywhere from minimum 2 years up to 10 years in prison and a fine not to exceed $10,000. Some of these things I know that you're already aware of because we had this discussion before you were placed on 10 years of deferred adjudication. So if your position is you want to represent yourself, then let's carry on. We'll talk more about it. If it's not, that you do want the assistance of counsel, then let me appoint you an attorney and then let's carry on.
Can I just ask you a question, Judge Martin?
You can, but I don't want you to say anything that could be used against you in court. Okay?
Okay.
All right, go ahead.
You know, I'm not one to let people just keep pushing me around. You know what I mean? Like, I do freak out. I mean, I do lose my cool sometimes, but it's never been without justification. You know what I mean? Like, my grandmother's husband pulled a gun on me. I got aggravated assault charges behind it, all because he was bullying, still to this day, bullies my Down syndrome uncle, who hates living over there now. And I can't be there to protect him because of him. You know what I mean? And try to tell y'all that you pulled a gun on me. My grandma told y'all she pulled a gun on me. Nothing ever happened. Got picked up on this charge. Someone tried to steal my truck, hit me over the head with a bat to where I'm bleeding down my head. No one even bats an eye. Doesn't ask any questions about who hit me, why they were trying to steal my truck, whether or not I want to press charges. I've always had y'all's back and y'all never had mine.
Now the tension really builds. Judge Perkins calmly but firmly lays out the law, explaining jurisdiction as clearly as possible while Destiny doubles down on her living woman defense. It's the classic face-off, courtroom reality versus internet mythology. You can sense the judge's restraint as he offers her options, hoping to pull the situation back into sanity. But she's already in deep. Every word adds weight to the standoff.
Well, Mr. Atkins, there's nothing in the motion to adjudicate about new charges, about an assault. There's nothing in there. It says that you didn't show up to probation, you didn't pay your fees, you didn't do your community service, you didn't take a class. It has nothing to do with any of the things that you've mentioned, okay? So at this point, to resolve those, if you have evidence that rebuts that or mitigates that, then that's where we have to get to in the process. And the only way to do that is either represent yourself with the court's permission, or have an attorney that works on your behalf that you give information to, and they argue to the court how you're not legally liable for these charges, or that they should be mitigated because of your circumstances in life. That's what we're trying to get to. Obviously, today is not going to be a resolution. Today's not the resolution. Today's not the hearing for that. Today is what we call a pretrial type hearing. And so the only issue before you and me right now, Mr. Atkins, is who's going to represent you? Is it you, or is it going to be an attorney that I appoint to represent? And I just need to know, if I appoint an attorney, are you going to work with them and do your best and let them represent you, or are you going to be difficult and grieve them and file complaints and make accusations?
I've never given y'all problems like that, Mr. Martin.
I'm not saying you have, Mr. Atkins. I'm not saying you have, but I'm just saying I have to ask that question, because if you believe that there's a religious conviction that you should not accept the help and assistance of an attorney, that may be an underlying motive for you to not work well with an attorney. So I like to know these things going in. And of course, I've been in this position many, many times. And so I've learned over the years to ask these questions because I've seen this become an issue with people in the past. And I just need to know if that's going to be you, then let's don't talk about having an attorney. Let's talk about representing yourself. And if you're going to be able to do so intentionally and knowingly, that you're forewarned on the disadvantages of self-representation.
No, I guess. Will you please appoint me an attorney?
And here it is, the breaking point. Destiny invokes UC 1 to 308, the ultimate sovereign citizen wildcard, insisting she doesn't consent to jurisdiction. Judge Perkins stays composed but done with the circular talk. With one sentence, he ends the loop. I'm going to put you back in the waiting room. It's that perfect courtroom moment when logic finally taps out and procedure takes over. You can almost hear the virtual door slam.
Yes, I will. I will do that. So, Ms. Taberham, do you need any paperwork from Mr. Atkins?
He's not completed the affidavit, but
Go ahead and have him complete the application.
okay.
I think I already know what the finding is going to be, but we do need this for our compliance with state law. So fill out the affidavit of indigency, request for court-appointed counsel. Let us review that. If you meet the qualifications, and I'm pretty confident you will, then the court will appoint you an attorney. I believe in your underlying case, you were represented by Mr. Jeff White. Is that correct? And I believe, I think I remember that's someone that your family members hired for you. Is that correct?
Paper out of my money, but yes, sir.
All right. Do you have money to hire an attorney?
No, when I went to prison, I gave my mom the rest of the money that I had. She blew it.
All right, then just go ahead and fill out the paperwork and then let Ms. Taberham tell me where we stand on our appointment process, okay?
Sure.
All right, you can go ahead and have a seat. You don't have to stand.
What follows is pure poetic justice. The narrator cuts in with sharp wit, revealing that Judge Perkins passed on the matter, and our would-be legal scholar decided to leave and never return. The outcome? A shiny new bench warrant. Short, punchy, and oh so satisfying. A crisp reminder that the courtroom isn't the place for fantasy law. Now, we move on to someone else who's about to test their own beliefs in spectacular fashion.
We are just ready to jump straight into our civils.
Yep, and I've got Preferred Credit Union versus Franthia Price next. Is that all right?
Yep.
We are here in the case of Preferred Credit Union versus Franthia Price, case number 25-05340AE. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court for a motion today, although it was not clear to me what the nature of the motion is. So as an initial matter, Ms. Price, would you state and spell your full name for the record, please?
I just want you to know, Your Honor, I'm here especially, not generally, and do so sui juris as the authorized agent for the Franthia family of the Price estate. So my appearance is strictly limited to the matter noted today, and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or implied legal disability or association with any bar guild.
Well, I get it, Ms. Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
Franthea, Franthia.
All right. Last name Price, Price.
I am.
Very good. And Mr. Bakikio, would you place your appearance on the record, please?
Thank you, Your Honor. May it please the court, Stephen Buquicchio, Buquicchio, P number 62076, on behalf of the plaintiff preferred credit union.
Very good. And Mr. Bakikio, this is not your motion. This is Ms. Price's motion.
Switching states and stakes, we meet Seth Atkins in Texas. Judge opens with calm authority, laying out the motion to revoke probation. Then comes the kicker. Atkins wants to represent himself. The judge's tone tightens, cautious but measured, like a man walking on eggshells over a minefield of bad decisions. You can tell this is heading toward a tense debate on faith, freedom, and foolish confidence.
Let me just pause you for a minute, Mr. Bakikio. Something I did see that I did recognize as I paged through the file was the affidavit of a transcript of the lower court record, which is normally produced in a case that comes before me on appeal of the district court decision. Are you aware of a notice of appeal filed?
I am not aware of that, Your Honor. I suspect what was done here, Your Honor, was in the lower court. The judge indicated to Ms. Price that she's ruling in favor of preferred and she was welcome to appeal that. And I suspect this is her attempt to appeal that. And to the extent Your Honor is ready to rule on her appeal and either, overturn the lower court's decision on the judgment or some other ruling here, I'm going to proceed as though she is seeking to undo the judgment that was entered against her. That's all I can surmise by this, Your Honor.
Yeah,
Okay.
if I may speak.
Yep, go ahead, Ms.
I
Price.
believe the opposing counsel has stated he has not received an appeal. I have sent that, all the information you received. He's received that. I have the record, that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely a simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record, that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract. And lawful consideration, if it's not done, is violation of a contract as well.
Here's where it hits peak drama. Atkins claims the Bible says not to trust lawyers, and the judge, sharp as ever, challenges him to prove it. The courtroom turns into a scripture showdown, with every verse questioned and logic taking center stage. The tension is brilliant. Faith meets law, belief meets burden of proof. When Atkins struggles to find his verse, the room goes silent. It's awkward, human, and grippingly real.
Your Honor, as a procedural clarification, Your Honor, to the extent Ms. Price does supplement her appellate filing and the court finds that it is inconsistent with the appellate rules, will another hearing be required, Your Honor, or?
No, I'll just sign an order of dismissal if I don't have the proper documents to initiate the appeal.
Terrific. Thank you, Your Honor.
Very
So,
good.
Your Honor, you said I have 15 days to get the information, because I believed I sent all of this stuff in appropriately. I went into and handed it in and got the proper documentation. And the fact that you said you don't have that information is a little.
Yeah, no, I do have a bunch of
about it.
stuff that you filed that appears to have been printed out by you. The one thing I have, and the only suggestion I can make, Ms. Price, there is a legal assistance center on the 4th floor of the courthouse. If you talk to them and say, gee, Judge Rossi said I was missing some stuff on appeal, they can at least direct you to the proper forms to file, to initiate an appeal, because the one thing I did receive here, was, the notice of filing of transcript and affidavit of mailing, and that's on a Michigan court form, that I recognize. And, what I then got was a transcript of that hearing, the last hearing, it appears, in front of Judge Sturkenberg. However, there is more stuff. They need to, what really they need to do is transmit the entire record, of that case, or you as the party need to assemble that record, on appeal, the record of what happened in the lower court, and get it to me, on appeal. And that basically looks like those transcripts, plus any paper documents in the court file that happened in the district court. And I don't see any of those in my appellate, file here.
They told me that I put there that they was going to mail it to you. They mailed me a copy, and they said they was going to mail you a copy because I purchased the transcripts and everything.
Yep, and I did get the transcript, the one, but that's just the transcript of the the hearing on appeal, and that is part of what I need. I said I didn't have a claim of appeal. I stand corrected, as I'm paging through here. And I have to tell you, Ms. Price, the filing of the additional documents here, I know you believe it's important in helping me to decide your case, but I can tell you what it's doing in a practical sense is making it really hard for me to file, just to track the documents that actually do trigger my duty to decide stuff on appeal. So I do have a claim of appeal. Looks like it was signed by you on June the 13th of 2025. So really what I need on appeal then, and again, I'm also prohibited, as the folks at the Legal Aid Center are, from giving legal advice. But I can tell you, if I'm to decide any appeal, I'll need a copy of the entire lower court record on appeal. And the record on appeal, like I said, usually it's assembled by the parties to the appeal. Usually you, as the person, the individual appealing the decision of Judge Sturkenberg, are the one that's going to put that together. Mr. Bequicchio can contribute to that record if he wishes to do so. And then that gets submitted to me, kind of as a, here's what happened at the lower court. It tells the story of that in those filings and pleadings filed at the lower court. And then you file a brief on appeal, and your brief makes the arguments as to why Judge Sturkenberg made legal errors in her decision making. And since I'm requesting that brief now, I just thought I was needing the claim of appeal, but since I have a claim of appeal that properly initiates the case on appeal, what I really need then is that record on the lower court, and then I need a brief from you explaining the errors that you think Judge Sturkenberg made. And I'll tell you, I will not be receptive to documents telling me that Judge Sturkenberg or I didn't have jurisdiction. That would be in effect saying, Judge, I'm arguing that neither of the courts could really decide this case because of my legal status, sui generis, or whatever magic words you're trying to invoke there. That just doesn't work. And the reason it doesn't work, particularly on appeal, is I have to have jurisdiction to decide the appeal in the first place. And if you're telling me I don't have jurisdiction, you're as good as telling me, as judge, dismiss my appeal because you can't decide it anyway. And so in other words, you got to give me more than that. It's got to be an argument based on Michigan law as to what mistakes were made by Judge Sturkenberg in the court below, and then I can decide the matter on appeal. And since I'm looking for the brief on appeal, that's a little harder to put together along with that whole record. I'll extend the time for the filing of the record on appeal and your brief on appeal. I'll give you 60 days from today's date. We're at July the
25th.
25th. Yeah, sorry, my glasses. I'm using a backup pair of glasses because my regular ones are in the shop. So yeah, 2 months from today will bring us to September 25th to have those documents filed. And then I'll be able to decide those. And I'll also tell you, Ms. Price, the way it works on appeal is I don't need to grant, you can request oral argument, which would be another version. Today, really, this is more of a status conference. It's not so much oral argument because I couldn't make head or tail of what the file was asking me to do. You can request oral argument if you want it. I don't have to grant it on appeal. Sometimes I just review the record and the filings and, decide the appeal based on that. And of course, Mr. Bequicchio, after that 60 days can file whatever he wants in response to, your arguments on appeal. And likely that'll be a motion to dismiss the appeal saying, Judge Sturkenberg did everything right. And there's nothing to look at here, folks. So that's kind of how it works on appeal, just for your information. And like I say, if you need help with at least the forms part of it, the Legal Assistance Center on the 4th floor of the courthouse is a good resource for that.
Okay, so just for clarification, because I'm going to do this right this time, this coming next time.
We close with emotion and hard truth. The judge patiently warns Atkins of the real dangers of self-representation, explaining the risks, the years, the weight of every decision. Then Atkins breaks. His emotions pour out, frustration, pain, and regret all at once. It's the kind of raw honesty that stops you cold. A man trying to stand tall but drowning in his own fight. If you enjoyed this journey through courtroom chaos, make sure to like the video, subscribe to the channel, and we'll see you in the next one.
There's 60 days you need to brief on appeal explaining the errors of the lower court.
Correct. And the record.
And you need a complete record of the two hearings that had taken place.
I need the complete record from the lower court, and that would start with everything from Mr. Bequicchio's complaint that he served you with and the proof of service and all that stuff. Typically, there's a copy of it. Would be as if you grabbed the file from Kentwood and made a copy of every piece of paper in it.
Okay.
Plus the transcripts.
Okay. Plus, you still need the transcripts as well?
No, you already filed the transcript. If that was the only hearing in the case, were there other hearings?
There were none, Your Honor.
Okay, so that was the only time that you two argued in front of the judge. So I don't need any additional transcripts. I just need the record on appeal.
Your Honor, there may have been a pretrial. I can't remember whether or not that was on the record or not, Your Honor. But if it is indeed on the record, the lower court record would include that, of course.
Very good. All right, so that's what I need is that record from the lower court. Mr. Bequicchio, I think the appellate rules allow you to weigh in and supplement the record or collaborate on submitting the record to me. I'll leave that to you as to how much you're going to participate and assist with that production. But you two can talk to each other. The goal being to get everything in front of me that I need to decide the arguments that you make in that brief on appeal, which is where you get a chance to make your substantive argument as to any errors made by Judge Sturkenberg.
Thank you, Your Honor. I will say, to clarify from our position, we did respond to the filing of Ms. Price. With that, we included the complaint, the answer, and our motion for summary disposition, and Ms. Price's response to that motion for summary disposition. So that should make its way to the court file. I don't know whether that would be deemed an official record as far as the appeal is concerned with certified documents, but we did put the underlying materials in our response. So that will be contained in your file. And
copy obviously went to Ms. Price, so she should have received all those filings as well. And normally, right, there is the certified record on appeal gets a simple one-page document from the district court saying this is everything we have in our file. So I would accept either way. If you want to supplement what Mr. Bequicchio sent Ms. Price, or whether you want to just go to the district court and say, hey, I need a whole copy of that file because Judge Rossi's asking me for it, and it's got to be certified because it's on appeal. they at least have done that before down there at the Kentwood Clerk's office. So it'll at least give you a starting point as to what to do. And like I say, I think I'd make my first stop the Legal Assistance Center so you can walk in there with the right form when you go to Kentwood District Court.
Thank you. And then do I use the same case number as well?
No, it'll be assigned, and it already has been assigned a new case number on appeal, which is the one we're here on today. It's 25.
Yes, that number, that's the one I'm speaking of.
Yep, that is the appellate case number.
Okay,
Now, when you're talking to Kentwood and if you're looking for
It's
the
a different
district court
number.
record, then you got to
Yes.
go with that number down there.
okay, thank you. I appreciate your help, sir.
Very good. Good luck, you ma'am.
Thank you.
Thank you, Your Honor. Thank you, Ms. Price.